Let us bring in attorney Lexie Rigden. Lexie, any chance the Supreme Court upholds this Colorado decision, especially in light of their inclination to always defer to the will of the voter and, let's face it, the precedent that that upholding this decision would mean for all 50 states, because at that point you could have a bunch of people just randomly bringing suit, even in a state like, I don't know, Alabama, even in a state like Texas at that point.
Right. Well, Todd, I'm not a betting woman, but that's exactly what the problem is here, is that it sets a very bad precedent that this is kind of like a blueprint for other states to go out, which this hasn't happened in other states yet, and file something like this and try to get him removed from the ballot. And that's why the Supreme Court at this point really does need to weigh in on it, because there's such a split. You have certain states saying that it's not a valid challenge, basically mostly on procedural grounds. And then you have the Colorado Supreme Court running 100 yards with this football and ordering it in the most broad terms, basically granting all of the relief to the electors here. And now we're just going to have to see what the Supreme Court says about it.
And there appear to be two basic questions involving this case. The first one is, did Trump engage in an insurrection? And the other one is, does Section 3 of the 14th Amendment, which this whole case is based upon, does that apply to the presidency? So what do you think about those two things?
Well, and that was really the dispute, because the lower court in Colorado said, we believe that he did commit an insurrection. And that's interesting, because the dissenting justices said, basically, wait a minute, this election code that we have wasn't meant to address such a complex legal question. Our election law is meant to address whether somebody has enough signatures or maybe was born here or how old they are, but they weren't meant to address this, especially in such a truncated time frame. And so they took 5 days worth of evidence. They determined that he committed an insurrection, and then that's how they came to this decision. But the lower court basically said that the 14th Amendment, Section 3, doesn't apply to the presidency. And so the Supreme Court of Colorado has said, oh, wait, yes, it does apply to the presidency. And that's why we're in this pickle now. And the Supreme Court is just going to have to rule to come to a conclusion on this, because this is a very slippery slope for other states, especially swing states, on both sides, quite frankly, because what an insurrection is not well defined.
Was Donald Trump convicted of insurrection in Colorado? I was unaware of that. I follow the news pretty closely. I didn't hear that. Did you, Lexie?
I did not. And,
okay.
And that's one of the things that the censors pointed out, that he hasn't been convicted of.
Because so then there's no due process. And I think that is one of Donald Trump's two main arguments. One, he hasn't been convicted of anything. So there's no due process with regard to that point. And second, Colorado courts have authority to decide matters of federal elections. I think both of these are his main arguments. What say you?
Well, that's right. And that's what other states have said. That, I mean, there's some precedent for that other states have said that this is not something either procedurally or on ripeness grounds that we're able to come to an agreement on. So we're not even going there. The plaintiffs in those cases couldn't win. And so Colorado has gone on a very different path here.
And just to back up a bit, because just putting myself in viewers' shoes, they're just waking up, maybe getting ready for work, pouring the coffee, and we're talking about Section 3 of the 14th Amendment, and this whole case is based upon it. Can you explain what that is?
Sure. Section 3 of the 14th Amendment was actually added to the Constitution after the Civil War, and it was meant to prevent people that were working in the Confederacy or supporting the Confederate government from holding office. And so the main dispute here that the Colorado Supreme Court overturned the district court on was whether that clause actually applies to the office of the presidency. And what the district court said is that it doesn't apply to the office of the presidency, because it doesn't one of the reasons is that it doesn't specifically say that in the Constitution. And the Colorado Supreme Court says, basically looked through the Constitution and came up with a way to basically justify the fact that it does indeed apply, that section does indeed apply to the United States presidency. Mm-hmm. And that's really why we're here right now. And that's probably one of the main questions that the Supreme Court would have to determine.
It's a complex case, and it's likely headed all the way up to the Supreme Court very soon. There's also the political implications of this. Eric Trump tweeted, prediction, this Colorado decision will add 5 percentage points to Donald Trump's already runaway polls. So we will be watching on that front as well.
My prediction, Lexie, on the 14th Amendment thing, the Supreme Court is known to punt. They're known to write around things to try to avoid, just because I think if they do answer that question, that kind of has major implications, not just for these cases, but a lot of other cases involving Donald Trump. So I wouldn't be, maybe I'm wrong on this, maybe I don't know what I'm talking about, but I wouldn't be surprised if they just tried to avoid it on the due process. But we'll see.
We're going to hit the ground running in 2024.
Lexie,
thank you so much for joining us.
I'm Steve Ducey.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.